Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Malone Hatley PC, and this is our podcast, I Now Pronounce You Divorced. Today, as always, I'm joined by Rebecca Malone and Mr. Dan Cuneo, and we're going to talk about something that I think a lot of people overlook in the divorce process, and that is the role that estate planning can play in the divorce process. When we're going through and we're working with clients, we so frequently see that there's a huge intersection in divorce, a life-changing event, and updating your estate plan or even starting to think about an estate plan that is frequently overlooked. So, Rebecca, I want to start with you. Can you kind of walk through and explain to us what divorce and estate planning, how does that work together?
Sure. So it is unfortunately frequently overlooked until it's too late, right? And what you might not be thinking about, what might not be at the front of your brain, is that by being married to someone, they have a right to inherit everything from you and vice versa. And when you're first starting out in a separation, that may not be what you would want to have happen, right? You might have children that you're trying to protect. You may have other family members that you want to take care of. And so there are ways to make sure that you can do that and not benefit a spouse. And so unfortunately, we have seen cases where someone will be going through a separation, but they're not fully divorced yet. One of the parties passes away and the other side inherits everything, right? That's not what you want to see happen. And so part of being in family law and being a family law attorney is recognizing all the different ways that something can impact your client or impact their case as you're going. So we need to be looking at what the plan is, if there is a plan, if you've ever written documents, how we can sort of create a Band-Aid to cover you between now and the time that you actually get a divorce, and then creating a more holistic plan once you're through and to the other side of the divorce. Because if you have minor kids, especially, after the divorce is over, if something were to happen to you, that other parent can still end up controlling the money on behalf of the kids. And again, that's probably not what you would want to see happen. So the only way to get around that is by having a solid plan in place.
And, Dan, Rebecca kind of talked about the Band-Aids put in place during the divorce process. Can you kind of explain to us what you think those Band-Aids are and what you advise your clients to do?
Sure. Oh, when Rebecca was talking, the thing that popped in my head first was holistic, right? And clients have no idea when they're going through a divorce or a separation. And sometimes lawyers or even clients can get just caught up in just that myopic of, I need to get a divorce or I need to get a separation. What can I do? But the holistic approach is looking at everything from beginning to end. And that's just not your certificate of marriage to your decree of dissolution. It's everything that's in between, which are estate planning documents, which could be wills, which could be trusts, which you're looking at retirement plans, everything, right? And you think of a Band-Aid as, okay, well, we're going to go through this, we're going to be amicable, and we want to just try to dissolve what we have, and we'll split everything 50-50. Well, what does that really mean? It's not just looking at assets, it's digging in, if there's a will, what does that will provide? Who are the beneficiaries? If it's looking at a trust, who's the trustee or their co-trustees, and what are the terms and conditions of that? And what type of trust is it? Is it a living trust? Is it a revocable trust, an irrevocable trust? And this also reminds me of this interesting case that I had to where the clients were pretty affluent, and they had a trust involved, and in that trust was a will, and they had certain property. And in order to benefit my client, instead of paying out a lot of alimony, what we did was we were more creative in that trust and allowed some control and some access to that when my client would pass. But we limited as far as what that percentage would be and what that allocation would be. And how that helped out is at that time and where I was licensed at, alimony was taxed. And so it was a better deal for the my client at the time who I was representing that was receiving the money as opposed to the payor. So it was the payee. And so at that time, we were able to really take advantage instead of having the money being taxed. Let's just kind of put it into deferred comp per se, right? And so what we ended up doing was still giving my client some control over that trust to where, and a usual divorce, and I say that in quotes, right? You're not going to advise your client if you're on that side to say, oh yeah, go ahead and allow that spouse to be the beneficiary or a co-trustee, because you want to really try to limit, as Rebecca said, their control. And so in this case, it really benefited my client. But as far as band-aids, you really want to limit the amount of band-aids you're using in a divorce case, because at the end they're going to have to be ripped off. And when they get ripped off, you don't want your client to come back to you and say, well, wait a second, how is my spouse still have control over my assets when we're divorced? And that's where looking at the estate planning documents really comes into play.
And I know that when our clients come in, we sit down and we actually have them sign a medical directive and a power of attorney. Rebecca, can you kind of explain to us why we have our clients do that?
Sure. So again, unfortunately, we've seen some pretty sad cases, and we've seen situations where parties were separated and someone was in an accident. They weren't able to communicate, they're on life support, life sustaining treatment, and the other spouse was able to make decisions about the healthcare. They were ultimately able to stop the life support and the life sustaining care that was going on. So again, that's never what you want to see happen, and it's a very, hopefully it's a low probability, right? But it's out there. And so it's one way that we want to ensure our clients are protected when they come in, to say first, do you have a power of attorney or do you have an advance directive that names your spouse as an agent? Because most couples do, when they go in and get their will done, they also are doing a power of attorney and they're naming each other as the primary agent. And there's a lot of harm that can come from that once you're in a separation situation. So making sure we're revoking those old documents if they're out there, and then putting a new agent in place. If you have a family member, a friend, a mom, a sibling, whoever, who can step into that role and be your agent, we want to go ahead and execute those documents now to make sure you're protected should something happen while your case is pending.
Yeah, you talk about the medical directive and the power of attorney, and even though it's rare, it still happens. I mean, quite a lot. Within our organization, we see somebody have to avail themselves of those protections probably at least once a year. Where they get into a car accident, they get very sick, something happens to incapacitate that person. And now the soon to be ex spouse gets to decide what life saving treatment you get. It's not a good idea. Or you're incapacitated and you give power of attorney to your bank accounts to somebody you trust, like your parents or your siblings or even an adult child, so that your soon to be ex spouse can be like, oh, they're incapacitated, I'm going to go drain the bank accounts, which we have seen. And we have seen it. I mean, unfortunately, we've seen the detrimental side of it, of death. I had a client that had just retained, and he got sick, and the wife went in there because she was going to have to pay him spousal support. Went in there and said, pull the plug. And the doctors and we all filed emergency motions to try to stop it with the courts, and we couldn't, because she's the one that got the ultimate say. And it was before we could get that medical directive in place. And that was a very unfortunate thing to watch happen, was this guy that he would have come through. And that's what the doctor was trying to tell the court. But it wasn't the decision of the court. It wasn't the decision of the doctor. It wasn't my decision. It was the wife's decision. So, Dan, can you kind of walk us through, you kind of said it's not about the certificate of marriage. It's not about the order of dissolution or the order of divorce. It's about those next steps. How do you convince somebody when they're going through this very emotional process? It's expensive too. They're going through this very expensive process, to take a step back and look at it from such an analytical point of view.
It's tough because you're right. It's an awful experience, and it's highly emotional and it's highly sensitive. And to have the additional sensitive conversations of, well, let me take a look at your will, or let me take a look at your medical directive or your POA, power of attorney. and really dig into advising them. We're looking out for what is your best interest. And I've had situations where the client just was adamant that they didn't want this divorce, or they were going to, work on this and be amicable. So in those situations, which come up more often than not, it's, well, let's try to be smart about this, and let's at least temporarily amend what you have, because you can always go back and change it if it works out. But at least let's amend it to where, if you don't want to remove your spouse because maybe they may take that as a act of aggression or as a preemptive strike or whatever you want to call it, then add qualifiers in there and add someone else that has to agree on these decisions, or have a professional weigh in and say, based upon my professional opinion, the probability of this person making it is X%. And then you can put in there, based upon what the expert is saying, the doctor, then we can make that decision. But you have to have at least 2 or 3 people agree upon it. And same thing with finances. If there's going to be any type of withdrawal, you just don't want one person going in and saying, I have this document here, give me, X dollars amount. Is they have to talk it through with other individuals, and then collectively they have to decide. And then if no one can decide, then it's always best to have a third party. And that third party, I would recommend just be another lawyer, because they can analyze and look at the documents. And that's how I've approached it in the past. But to your point in the beginning with the question, it's a delicate conversation, but it's one that has to be had.
You talk about a holistic approach, and, I get a lot of questions, what do I need to be looking for when I go through a divorce? You need to be looking for somebody that wants to give you a holistic approach, because like you said, sometimes those questions are hard. We are already dealing with very emotional people. Not they're no emotional people, they're people going through very emotional times. And then to say, well, let's talk about what happens if you die.
Right.
And of course that's a bit bombastic, but it's what it kind of feels like to people. Like, okay, you're divorce and death. You want to talk about taxes now? I mean, anything else that hurts? Like, what else do you want to talk about? Unfortunately, we don't do taxes, so we don't have to worry about that. Rebecca, kind of touched on it a little bit, that when somebody's going through a divorce, it's a big life change. Can you walk us through what the difference between a will and a trust is, specifically for people who have children who are under 18 years old, why one might be better than the other?
Sure. So, in general, and I'm speaking from my experience in Virginia, but in general, if you're using a will, then everything has to go through probate. And if you're trying to leave everything to a minor and it's going through probate, then someone has to be appointed as guardian, basically on behalf of the money. So, not necessarily the physical custodian of the children, but just someone to manage the money on their behalf until they reach an age where they can directly inherit. What a lot of people don't realize is how expensive that is in going through probate. So, in general, sort of the national average statistic is that the probate process itself costs between about 3 to 5% of the gross value of the estate, not the net. So if you have a house that's worth $500,000 and you have a loan on it for $300,000, those probate fees are based on that gross. They're based on that $500,000 figure. And that is a good chunk of change, just right off the top of everything. And then you add another layer to that of getting this guardian appointed for the money on behalf of the children. That person has to qualify for and post a bond with the court, just so that, as a fiduciary, that if they do anything wrong, that the children would be reimbursed. But that payment of that bond is also getting paid out of the estate. And in a recent case I had, where the value of the inheritance was, I think, around $50,000, the bond costs about $1,000 a year, and the child was 9 years old. So every year there's going to be $1,000 coming off of the inheritance, right? We're just chipping away and chipping away and chipping away. They also have to file certain reports. You have to do other certain filings, which you probably need to hire an attorney for. Again, it probably depends on your jurisdiction, but Virginia, we don't like to use a lot of forms. So it's mostly attorneys that have to draft these things and file them with the court. So all of that together, you're looking at a pretty big chunk of change that's coming off of your beneficiary's inheritance. Now compare that with using a revocable trust. So using a trust, you completely bypass probate. You don't have to go to probate at all. There's none of those costs and fees. You can designate who you want to act as the trustee on behalf of your children. There's no reporting, no bonds, none of those fees that are again coming out of that. If you choose a corporate fiduciary like a bank, they do charge a fee for their service, but you can choose an individual. It can be a family member, it can be whoever you want. And then they're in charge of making payments on behalf of the beneficiaries according to whatever you say. So if you say, I want, the inheritance to pay for their school, I want it to pay for my children's housing, I want it to pay for a car or a trip or whatever for college, this and that. And then they get whatever's left once they hit a certain age. And you choose the age. So it's not just 18. You can say it's 25, 26, 30 years old, whatever you want to pick. And then they get whatever's kind of left in the bucket at that time. So that's the big difference in a will versus a trust. Wills seems, and they are, a little bit more straightforward to set up, but on the back end, the administration of them is so much more costly, so much more convoluted compared with a trust that takes a little more effort on the front end to set up, but on the back end, the administration, so much more seamless, so much easier, and you have a little bit more control. So especially choosing, who's going to be managing the money and what it's going to be used for, that makes a big difference for a lot of people versus, under a will, they just get the money when they turn 18 and they're going to go buy a car or do whatever silly thing an 18-year-old wants to do with an inheritance. So those are kind of the big key differences. So for most of our clients that have minor children, we're going to be gravitating towards that revocable trust option. You're also ensuring that that other parent isn't going to get control of the money by going that route because you're already choosing who the trustee is going to be. The trust is already in place. It's already set up versus going through probate when the court is going to default to letting that other parent have control over the money. That's definitely not what you want to see.
And Dan, we talk about trust, and I think that we all think. I know I personally think about like the Vanderbilts, these old money trusts that we grew up reading about that have supported generations upon generations of people. How do you talk to people about getting rid of the stigma that trusts are just for the ultra wealthy?
Sure. I mean, Rebecca's touched on a good hunk of it as far as the importance of one when you have children. And she didn't mention anything about a qualifier, right? Like a certain dollar amount. It's if you have kids and you want to make sure that they're protected, making sure that they have the benefit of the money to help them out with whatever needs may arise, then that's where that trust comes into place. So there's no limit. At least I can tell you where I'm licensed at in conversation with others. There's no limits as far as what you have to have from a wealth standpoint to create a trust. It's really more of what do you want to do to make sure that your family is protected. And then when you want to talk to an attorney who really has a lot of experience in trust, and stay away from firms that will say they specialize, because in most jurisdictions, it's against the rules of ethics to say that a lawyer specializes in a particular area. And I say that because there's so many law firms out there, but you want to make sure that you're speaking with someone that has experience in family law and has experience in trust and estates, because they really do go hand in hand. And you can get lost in the minutiae as far as what an actual trust means, because you have revocable and then you have irrevocable, and you want to make sure that what you're choosing is the best for you, because if you choose an irrevocable one, it's a lot harder sometimes to get out from underneath, and there you lose a lot of your control, and we're talking about control, right? And so if you do this irrevocable, you think you have control, but you really don't have control with a lot of the assets that are in there. But another caution that I have, and it's always good to talk to a family law attorney when you're dealing with trust, is because before the marriage, you want to make sure that if you're going to make that spouse your co-trustee, you could potentially giving them, making that trust marital asset. And you want to, as you're going through the process, when you're getting married, I remember doing seminars across the country and doing is when you're married, you're on the same side of the aisle, right? But then when you're getting divorced, now you're on separate sides of the aisle. And so you have conflicting interests. And in the beginning, what makes sense to you at that time may not make the best sense at the end. And so you just want to kind of plan ahead, as we what we talk about in these podcasts is what is the best for you, and what can we do to really help guide you to protect you. And I always caution clients when they come in before they're married that they want to make their new potential spouse be a co-trustee. There's just so many implications, and once that act is done, it's hard to get out from underneath that.
Well, I want to thank both of y'all for talking to me today about trust and marriage. We're going to come back for part 2 next week. So if you like this, hit subscribe. Join us for each week as we talk about these. And if you're looking for a divorce attorney, somebody that is, have them give us a call, because Malone Hatley PC, we truly are your partner through divorce and estate planning.
Hi, this is Dan Cuneo with I Now Pronounce You Divorced. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.